I think I got this right. We'll just wait a few minutes for somebody to join us. I am going to do... Okay, all right.
I'm going to do...
We are in.
Okay, all right. Going to do...
You're going to wait for the people to join us.
In.
I'm going to turn this one down.
All right.
I'm turning this one down so I can see the text messages. So if anybody has a question, I'll be able to see it in the chats. Now, I know 5 people have purchased these tickets. And I gave away 50 tickets. So we'll see who all shows up. Because if 20 people do not show up for this class, this will be the last class I do. Okay? So, I have given away 50 tickets. We'll see if those people who are really serious about this class will join us. We have right now 2 people watching, and we still have a few minutes. It's 1:59, so we're going to give it just a few minutes for some people to join us. Okay, guys, just be patient, and we will get started here in a few minutes. Okay, I'm going to give some time for people to hop in here, so let's give everybody just some time. I'll go ahead and play some music while we're waiting. That way, we have some music here. Let's see if I can find my daughter singing.
I'll go ahead and play some music while we're waiting.
I will find some music while we're waiting for others to join. Okay, guys. I have a oldest daughter who loves to sing. She has a very beautiful voice. I'm very proud of her. So I'm going to search one of her songs. We're going to play that song to give some time for people to join us. Alright, because we want people to be able to join us. Just waiting on people to join us.
I'm going under, and this time I feel there's no one to see. It's all really got a way of driving me crazy. I need somebody to feel, somebody to know, somebody to have, somebody to hold. It's easy to say, it's never the same. I guess I kinda like the way I'm gonna bang. Now the day bleeds into nightfall, and you're not here. Get me through it all. I let my guard down, then you pull the rug. I was getting kinda used to being someone you love. I'm going under, and this time I fear there's no one to turn to.
Just waiting for people to join us.
This all or nothing way of loving got me sleeping without you. Now we need somebody to know, somebody to feel, somebody to have, just to know how it feels. It's easy to say, but it's never the same. I guess I kinda like the way you help me escape. Now the day bleeds into nightfall, and you're not here to get me through it all. I let my guard down, and then you pulled the rug. I was getting kinda used to being someone you love, and I tend to close my eyes when it hurts. Sometimes I fall into your arms. I'll be safe in your sound till I come back around. But now the day bleeds into nightfall, and you're not here to get me through it all. I let my guard down, then you pull the rug. I was getting kinda used to being someone you love, but now the day bleeds into nightfall, and you're not here to get me through it all. I let my guard
There we we go. I was trying to find the chats. Hey guys, join me.
Getting kinda used to being someone you love. I let my guard down, then you pulled around. I was getting kinda used to being someone you love.
Alright guys, that was my oldest daughter. Let me go in. I want to let me flip this around. I'm going to put that right there. I'm going to record it. Alright guys, I'm not sure if this is going to record, so I had another lady that had purchased the ticket for today, and I'm not real familiar with the Facebook classes. This is kind of like my second try, and she let me know that she wasn't going to be able to attend today. I did give out 50 tickets, so we'll see who all shows up. It looks like we only have 3 today so far. We're going to give it another minute before we get started. So how is everybody feeling today? You ready to take some notes? Ready? I got all my notes. I came prepared. I hope y'all are ready, because I intend to give you as much as I can, as quickly as I can. But I am not a lawyer. Okay? I have successfully helped on 11 TPR cases where parents came to me and asked me to help them. They were facing a TPR trial and didn't know what to do. Lawyers were not helping them. So they came to me. I helped them prepare for it. I did not wait the day before. It was several weeks, sometimes several months in preparation for their TPR hearing. And every single one, we won. So I have a 100% success rate in turning TPRs back to reunification. I have successfully had one case that actually lost their rights, knew they were going to lose their rights when they came to me and asked for my help, and I told them, you're going to lose your rights. You didn't do everything that you needed to do to get your children back. You need to sign temporary guardianship over to a relative. You need to have an agreement with them, and they did. And after 2 years, you can reapply to get your rights back. But you have to document, you have to do A, B, and C, or you won't get your children back. And they listened to me, did everything that I told them to do. I mean, everything that I told them to do, they did. And praise the Lord, last year they got their rights that were terminated years prior. They got their rights back. So not only did I have 11 successful TPRs turned back to reunification, but I've had one where the parents had actually lost their rights and then got their rights back. Okay, so I have been successful in doing that, but I work with the lawyers. I am not a lawyer, but I help you prepare to give to your lawyers what you need in order to win. Okay, now how many on here are looking at TPRs, or you're just here to learn today? Can you let me know what you're here for? If you're a advocate wanting to learn how to help other people, or are you here for yourself, to learn for yourself because you're facing a TPR? What am I dealing with today? Advocates or people that are looking to help other people? Just put in the comments, because I want to make sure that if we have people here that are advocates, that I let you have a little bit more information on that, besides just those who are here for helping them 9 years ago. Okay, you're hoping to help others. Perfect. Okay. So, well, it's 2:07. I think those who decided to join us, we're going to be here today, are going to be here. So we're going to go ahead and get started. All right. I know going into a TPR, when you get that notice that, okay, so a TPR hearing is not just overnight. When I have these parents come to me 2-3 days before their TPR hearing, begging me for my help, I tell them it's too late. I know that's horrible to say, but it's too late. And what I tell them is, you either get a continuance so that you can work on this, because this takes time. This isn't something that you can just willy-nilly go into the court and think you're going to win. I work on cases 6, 12, 15 weeks to prepare them for their TPR hearing. This is not a overnight type of preparing, okay? And these lawyers that go in there not prepared should have their bar license taken. I've actually taken 2 lawyers' bar license. So it's just, the situation is different for everybody. And a lot of times a TPR, they don't understand why they can even do that if they're doing the services. And if you will go to your state, now I don't know what state you're in, and if you've paid for this class, I'll make sure that you have access if you're ever working with somebody and you need the Child Welfare Manual, the actual rules and guidelines for the particular state that you're working in. I'm more than happy to provide that for you, okay? My email is lucindagracepennington@yahoo.com. If for some reason I don't respond, it's blocked. So you'll need to email my other email, okay? You can demand a jury trial. A lot of states don't do jury trials, not for a TPR. You can demand one. I believe Missouri is also a jury trial. So is Florida. I think West Virginia might be. But you need to check your state laws. Some TPR hearings are not jury trials. The jury trials you do at the beginning of your case, not at the end of your case. Okay, and that's where this mistake is. I will tell you this as a disclaimer, I'm not a lawyer, but I always, when a parent comes to me, I have them relinquish all of their signatures to CPS, to every doctor, to every hospital, to every counselor, everything. I have them send out an affidavit notarized to every facility, every doctor, every caseworker, every lawyer, and relinquish every signature that you've ever done for CPS or any doctors or any medical records, school records. You submit it to the schools. You relinquish any signatures that they claim they have, okay? If you were foolish enough to sign a safety plan because of coercion or blackmail, you won't get to see your kids if you don't sign this, you need to relinquish your signature immediately. Okay, because the problem that we have when we're fighting a TPR hearing is when you go to try to get your records, they say, oh, I'm sorry, you can't get your records. Only CPS can. You'll have to go to CPS. And the parents are like, it's my record. Why would I have to go to CPS? Because when you sign that medical release, you gave it away to a third party who then tells who can and can't access those records. So when you sign that medical release for Children's Division, you have signed away your rights to your own medical records. So you need to relinquish those rights. Now you can download a form online off of the HIPAA, the federal HIPAA rules, for the doctor's offices, and then for the schools and for the caseworkers, you need to sign an affidavit, a petition of truth and facts, that for any purposes, medical, school, service plans, you relinquish all signatures and all agreements. Okay? You absolutely need to do that. That is the first thing I have my clients do. Sometimes the lawyers don't like that, but the fact is, we can't get the documentations if we don't. Okay? And it's already, they make it very difficult for you to get the documentation that you need. You need every documentation that you possibly can. Now, I have some parents that were really good and documented throughout their case. Then you have other cases where the parents didn't document. Over the age of 14, they're still minors. You can still, as their parent, get the documentation. Now, since this is a paid class, and I know I don't have any caseworkers in here, if you have your children's birth certificate and their Social Security and you have not lost your rights up to that point, you can actually contact all of their medical records and get all of their doctor's medical records through the billing. So if you can log in online, prove that you're the parent, you can actually pull up online their documents, their billing. You can find out what kind of meds they're putting your kids on that they haven't even told you There's been situations where we found where they were medicating these kids 5, 6, 7, up to 12 different kinds of pills a day, because they were getting paid to test drugs on foster kids and were not informing the parents what they were doing. Okay? So being able to log in, check your kids, that's also how I've been able to find missing kids that were in care, is by having the parents log in into the online Medicaid. Okay? That is how you are able to find the kids who are missing, because if you log in into the online Medicaid, you can find out where they are. Because you'll find out where the doctors are, you can kind of get a rough idea where they're at. Okay? Because they'll have to list the foster parent's address. Okay? I know it's a sneaky way of doing it, but unfortunately, sometimes you have to do what you have to do in order to find these kids that are missing in care. Okay, I had a kid go missing for over a year, and that's how I found it. Where caseworkers, the supervisor, and the guardian ad litem were in contempt of court, refused to produce this child. I had the ombudsman go with the court orders to demand to see this child, and they all quit. Okay? They switch insurance, but they're always on Medicaid. No matter what insurance you have, they're always on state Medicaid. So you can always log into your state's Medicaid and find them. Okay? That is just a fact. They get money. I just exposed Great Circle overbilling $2.3 million on one child. Okay? Because we were able to log in, pull up everything that they billed on all 3 of the insurance that the parents had. The father was a firefighter, and they were billing his insurance. Mom had her own private insurance, and lo and behold, they were on Medicaid. And so we compared all 3 insurances, proved that all 3 insurances paid them, and they were overpaid, okay, $2.3 million, okay, if they changed the name of the kids. Now, if the kids are adopted and you don't know the names of the kids, what you have to do is go to pacer.gov, I believe is what it's called, and start looking up the adoption case files and find your kids that way. It's a long, drawn-out process, and I have found adoptions through that site. It is a government site. Yes, pacer.gov. You can actually look up adoptions, you can look up guardianships, you can look up bankruptcies, all kinds of stuff, okay? Name changes, all of that stuff, okay? So it's important that, and I pay to have that service, so when I look up, and the caseworkers don't understand, I have a case right now I'm working on, and they were in breach of a HIPAA violation. One, the caseworker was testifying on the wrong case, and I'm reading through the transcripts, and I'm asking the grandmother, when did the father get overnights? And she's like, the father's never gotten overnights. I said, here in the transcripts, the caseworker is being asked about the dad's overnights with the kids, but the kids' initials aren't the same initials of the kids that are in question. I'm confused. Does he have other children? And she's like, no. And then I discover they were talking about the wrong case. It was the same dad's name, same caseworker on the case, but they were talking about the wrong case. So, incompetence. Okay, it should have been thrown out right then and there, but it wasn't. Okay, so a lot of times, and the only way I found out which case it was going through Pacer, going through every single case for that county. I mean, it took me days to find it. Okay, it's not easy. I took days researching, going through every single case with the name Timothy in it, okay, until I found it, all right? And then when I wrote the complaints for the parents and the grandparents, they're like, how did you know the case number? How did you this? And I'm like, I ain't telling you how I did your job and found out that you have a caseworker who's incompetent and testifying on the wrong case. So Pacer, I love Pacer. It's one of the main things that I use. I also look at Pacer when I'm doing background checks. I've also found on one of the cases that I'm working on, the grandparents who were not in the picture at all when the children were taken, And they decided to give these children that had never met these grandparents to this set of grandparents that for some reason was never in their lives, which was a big red flag for me. Why weren't they in their lives, and then all of a sudden they want to be in their lives? So I started researching. Pacer, beautiful thing. Found out that the grandmother had a misdemeanor felony charge for child endangerment for beating her stepson, and then was in 2 contempt charges against that charge for being around him when she was told not to. That's why she was never around the grandchildren, because she didn't think she could legally. Then all of a sudden, here's CPS showing up at her door going, don't forget, just forget about that misdemeanor. Nobody's going to know about it. We know about it. It was so long ago. We don't care. Here's your grandkids. We just don't want the other grandparents to have them. We'll let you have them. Yeah, they got a misdemeanor of child endangerment. She beat the child, okay, injured her own stepson. So yeah, that's going to be part of my lawsuit. And the way I found it was through Pacer. It's a great, great tool, okay? I really love it. It does take a lot of research, but it is helpful, okay? So thank you for sharing that, Nora. Thank you. I'm glad you found it. You do have to sign up for it as an account if you're an advocate and you're trying to look, and you're trying to find things. It's perfect. You can even request transcripts through there. Pages, it's public knowledge. Once it reaches a certain stage, you can actually download it. I love it. It's a great tool. Okay. Also, whenever I start a TPR hearing, okay, anytime, I can do it as an individual, but I do it as my company. So I'm a nonprofit. I'm a 501c3. So I do it as a nonprofit through my ministry, and I'm able to look up per page like 10 cents a page if I want to download it and print it out. I think it's like 10 cents a page. Well, you pay that to print out at what, Kinko's or whatever. So for me, it's worth it if I'm wanting to get documents and print them. Sometimes if I don't want to print them, I'll just take a picture with my phone, blow it up, scan it into my PDF file, and it print it that way for free. Well, it's not really free because I still have to print my paper and my ink. So either way, sometimes I do it that way. All right, so Child Welfare Manual. So if you're working on a case, somebody comes to you and they say, look, I have a TPR hearing in 3 months. I don't know what to do. I've done all my services. I've been doing my services. Or if you have a parent that hasn't been doing their services and they refuse to do their services, they're going to lose their TPR. Be honest with them, plain and simple, because here's the reason why. Let me read what the rules and guidelines. So what I do is I use the system against the system to beat the system. So I read their rules. I read their rules and guidelines. We're going to go over that a little bit today so that you can understand where they're coming from. So a lot of parents, they go into this TPR and what they try to do is say, you didn't have the rights to take my kids to start with. A, B, and C. I didn't do this. So they're trying to justify themselves on why their case should have never been opened. That's not how you win a TPR. The judge don't care. He's going to throw that out. He's going to say, we're past that. If you wanted to dispute that, it should have been done at the beginning. Okay? Now you're at a TPR hearing, not a beginning of your case hearing. Okay? So a lot of these parents, a lot of these advocates are like, oh, they shouldn't have taken your kids to start with. They didn't do this. They didn't do that. You're right. They didn't. They absolutely did not. But at this point, that's not how you win a TPR. Okay? I know the temptation is to sit there and fight them and duke them out. That isn't the time. Okay? In a TPR hearing, they have to meet certain qualifications in order to take your rights. So let's read through that real quick. I'm using the Missouri one because that's the one I've been doing since I started this. Okay? So termination of parental rights should be considered only after full efforts have been made to return the children safely to a parent. These proceedings may be initiated upon the request of the child's parent, voluntarily relinquishment, or by any other person, including Children's Division, making a referral to the appropriate juvenile office. So here's the beauty. They want to argue with the parents. You can't give up your rights. You can't give guardianship to anybody. They're in Children's Division custody. But did you hear that? They're lying. Because the very first sentence in their rules and guidelines states that the termination of parental rights should be considered only after full efforts have been made to return the children safely to a parent. These proceedings may be initiated upon the request of the child's parent, okay? And they can voluntarily relinquish, okay? You have the rights at any point in time to relinquish, give guardianship, TPR your rights to a relative at any point in time in your case plan. They lie to you and tell you you can't. That is not true. Okay? That is the biggest lie the Children's Division will tell you. And a lawyer will say, I can't help you do that. You can't give guardianship to your mother. You can't do this. You can't give guardianship to an aunt, to an uncle, to a cousin, to a friend, to a pastor. They're lying to you. Okay? And that's how I got those 2 lawyers debarred, because I used their own system against them to prove that they did not do as the parents requested. Okay? In certain circumstances, the division is authorized to file a petition for termination of parental rights without making the request to the juvenile officer with the assistance of Division of Legal Services. So a lot of times they don't get permission from the juvenile officer. They don't even know you're going into a TPR hearing. Okay? The family support team, in assessing the child's need for permanency, should consider the termination of parental rights if permanency through unification with a parent, and if adoption is a reasonable expectation and meets the child's needs. Okay? Once it's been determined that TPR and adoption will become the case goal, the division shall and still be required to make reasonable efforts towards reunification. They're required to do that, okay? Unless an order from the court states otherwise. So if you don't have a court order that prevents you from having visits, you are required to have visits, okay? Once it's been determined that a TPR, I keep losing my spot, I apologize. As part of the effort to prepare the parents for termination of the parental rights, the division shall continue to engage the parents in discussion regarding changing roles and relationships that may occur between the parent and child. Discussions of plans for visitation, family time that are in the best interest of the children, and planning for the immediate future and referral if needed services. The division shall continue to provide referrals to parents for requested services. These services are based on the specific parent's needs and may include grief counseling and other efforts to ease the transition during this time. Additionally, parents should receive education on issues related to confidentiality, search, and reunion. The division shall document any plans for the parents' participation in the adoption process when appropriate and desired. So a parent can be part of the process of an adoption. They cannot deny that. And a lot of times they do. And when you find that out, that's a form of child trafficking. And a parent can file a grievance against the division for not including them on the process of guardianship or adoption. So that right there is one of the grievances a lot of times that I write up, is when the division fails to give the parents due diligence on the reunification process and the adoption process. They have to be a part of that, okay? Termination of parental rights may be a simple legal process when all parents to the child are identified, located, and voluntarily relinquish their parental rights. You can do this at any point in time of your case, at the beginning, in the middle, and before you lose your rights. In fact, if you haven't done services, you haven't done the requirements that they've asked you to do, you didn't show up for visits, you didn't get clean, you haven't been stable for 6 months, then you should be looking for somebody to give guardianship to. Not adoption, guardianship. That is the only way to get your rights back, is if you voluntarily give guardianship to a family member, a kinship, or through a family relative. Okay? Termination of parental rights may be a time-consuming and complex legal matter if one or both parents object to his or her parental rights being terminated. That's why they have a hearing. In all cases, the facts and grounds for termination must be proven by legal admissible evidence in a court of law. So, if they refuse you your evidence, this is what you will quote to the judge about abuse of power. If he does not allow, okay, it is against criminal law if he does not allow evidence in this hearing, okay? Grounds for termination of parental rights must be proven to the court by clear, cogent, and convincing evidence. This is the highest standard or proof known to the civil law. It is essential that all the facts supporting termination of parental rights are carefully and thoroughly documented. Individual courts may interpret the involuntary termination statutes differently to be reluctant to pursue premature termination of parental rights. Staff may consult with the Division of Legal Services in addition to the juvenile officer on all cases where involuntary termination of parental rights is being considered by the family support team. So if you're going to a court hearing and having a trial of termination of parental rights, they have to prove it beyond a shadow of a doubt. And that's where, when you go in, it's not about whether or not they should have taken your kids. It's whether or not they can keep your kids, okay? So when considering a petition for termination of parental rights, the courts must apply a two-part analysis. This is important, okay? Take notes. The first thing the courts have to do is the court must determine whether there are statutory grounds for termination in the case under consideration. And second, if the petitioner proves that the statutory grounds exist, whether termination of parental rights is the best interest of the child. The court may deny a petition of termination of parental rights if the court finds that the TPR is not the best interest of the child, even if there are statutory grounds for termination. However, the court cannot grant a petition to terminate parental rights if the petitioner failed to prove by clear, cogent, and convincing evidence that the statutory grounds for TPR exist. That's why it's important to get all of your evidence together before you go into your trial. Don't wait for your lawyer. Don't count on your caseworkers. They are trying to prove that you cannot have your children. Okay? Do not wait. This is your one and only chance to prove that you are legally capable of taking your children back. Okay? Section 210.720 states, in the case of a child who has been placed in the custody of the Children's Division in accordance with the subdivision 17 of subsection 1 of section 207.020 or an Oh, it must be raining. Yeah, it's raining. Okay. I was like, what is that noise? Okay. In another authorized agency by a court or has been placed in foster care by a court, every 6 months after the placement, the foster family, group home, agency, or child care institution with which the child is placed shall file with the court a written report on the status of the child. Okay? The court shall review the report and shall hold a permanency hearing within 12 months, okay, of the initial placement and at least annually thereafter. The permanency hearing shall be for the purpose of determining, in accordance with the best interest of the child, a permanent plan for the placement of the child, including whether the child shall be continued in foster care or whether the child shall be returned to the parent, a guardian, or a relative, or whether proceedings shall be instituted by either the juvenile officer or the division to terminate a parental's right to legally free such child for an adoption. Okay? All right. So guidelines. Here's your guidelines. The guidelines for terminating grounds or triggering events for termination of parental rights. A petition to terminate a parental's rights of a child or parent shall be filed by the juvenile officer or children's division. Okay? If the petition is filed by another party, the juvenile officer or CD shall seek to be joined as a party to the petition when following grounds are present. Child has been in foster care at least 15 or the most recent 22 months. They have to be in foster care at least 15 or 22 months before they can TPR parental's rights. Okay? A court of contempt jurisdiction has determined the child to be an abandoned infant. Okay? The parent has left the child under circumstances that identify the child was unknown and could not be ascertained. Despite diligent searching, the parent has not come forward to claim the child. So that's those situations where a child will put a child at a safety box or whatever, and they don't know who the parent is. Okay? They can immediately adopt the child out for that purpose. But they have DNA now. They can actually find the parent. It's not that difficult. So if a court doesn't do a DNA test, they're failing this child. Okay? The parent has, without good cause, left the child without any provision for parental support and without making arrangements to visit or communicate with the child, although able to do so. So they base that when you miss visits. When parents are missing visits, they base that saying that you are abandoning your child. So when I was a parent aid company, I said, you can't miss visits. If you miss visits, they will use it against you trying to say that you're abandoning your child. And they do that all the time. Out of the 15 months that the child was in care, the parent missed 20 visits. That's a form of abandonment. Okay? So when you're talking to parents, you tell them, unless you are dying in a hospital, you better freaking make it to your visits. It is inexcusable to not be in a visit. I've had parents come up with every excuse in the book. Oh, I can't come. Do you have a job? No. Then there's no excuse. Oh, I missed the bus. Then get an Uber or start walking. Grab a bus. Grab a bicycle. Something. Get yourself to the visit. Hitchhike. I don't care. Stop having excuses. I had parents that would barter. I'll clean your house. Give me a ride to my visit. She would clean the neighbor's house because her neighbor had a car. And give me a ride to my visit. I'll clean your dishes, clean your house, clean the litter box. And she would barter with her neighbors to get her ride to her visit. Teach parents to be self-sufficient. They must not rely on children's division to get to their visits. Okay? A court of competent jurisdiction has determined that the parent has committed murder of another child of the parent or committed voluntary manslaughter of another child of the parent or aided and abetted, attempted, conspired, or solicited to commit such a murder or voluntary manslaughter or committed a felony assault that resulted in a serious bodily injury to the child or to another child or of the parent. So if this happens, they can immediately, they don't have to wait 15 months to 22 months. If a parent is guilty of murdering or involved in attempted or conspiracy, they can immediately put the baby up for adoption. Okay? The juvenile officer of the division may file a petition to terminate the parental rights of the child's parent when it appears that one of the following exists. The child has been abandoned for the purposes of this subdivision. A child's means any child for over 1 year of age at the time of filing of the petition. The court shall find that the child has been abandoned if for a period of 6 months or longer. Okay? The parent has left the child under such circumstances that the identity of the child was unknown and could not be ascertained despite diligent searching, and the parent has not come forward to claim the child, or the parent has, without good cause, left the child without any provision for parental support and without making arrangements to visit or communicate. Okay, and I think I'm repeating myself. I apologize. The child has been abused or neglected. They love this one. Okay, they put this on every case. Abuse and neglect, abuse and neglect. Okay, but they have to approve abuse and neglect. Okay, a child has been abused or neglected. In determining whether to terminate a parental right pursuant to this subdivision, the court shall consider and make findings on the following conditions or acts of a parent. Okay, a mental condition which is shown by competent evidence either to be permanent or such that there is no reasonable likelihood that the condition can be reversed, and which renders a parent unable to knowingly provide the child the necessary care, custody, and control. So if you're an addict, they consider that a disease that is incurable, and if you can't be clean for 6 months, you won't get your kid back. Okay? You have to be clean for at least 6 months. Okay? Chemical dependency, that's the addict, which prevents the parent from consistently providing the necessary care, custody, control of the child, which cannot be treated to enable the parent to consistently provide such care, custody, and control. Okay? A severe act, recurrent acts of physical, emotional, or sexual abuse toward the child or any child in the family by the parent, including an act of incest or by another under circumstances that indicate that the parent knew or should have known that such acts were being committed toward the child or any child in the family, or repeated or continuously failed by the parent, although physically and or financially able to provide for the child adequate food, clothing, shelter, or education as defined by the law, or other care controlled necessary for the child's physical, mental, or emotional health and development. Nothing in this section shall be construed to permit discrimination on the basis of disability or disease. Okay? That's where the ADA comes in at, the Americans Disabilities Act. You need to educate yourself on the Americans Disabilities Act, because when they take a parent that suffers from, say, bipolar or schizophrenia, and they are on medication, but as long as they're on their medication, they're fine. Okay? And a lot of times I encourage parents to have a form of guardianship set up, so if they ever have to go in for treatment or anything like that, they have temporary guardianship already set up just for emergency cases, so that Children's Division can't use that against them as an ADA liability. They can't hold that against them in taking and removing their children. Okay? Because you are preparing for that situation where can everybody hear me okay? This thing just popped up saying key frame rate too low. I don't know what that means. Everybody hearing me okay? I'm hoping everybody's able to hear me okay. Okay. I don't know what this means. I'm going to exit that out. Okay. So the child has been under the jurisdiction of the juvenile courts for a period of 1 year. That's 12 months. Okay? or the court finds that the conditions which led to the assumptions of the jurisdiction still persist. So that's where I use the petition. Every parent gets one at the 72-hour hearing. It's the petition of the reasons why the kids were taken into care. Now, I do use that in the TPR hearing, okay? But not in the sense that you're thinking, okay? What I do is I do an affidavit of truth, petition of truth and facts, okay? So if they try to use this against a parent of the petition of why the children were taken into care, okay, if they try to use that, the juvenile officer tries to use that, you have your own statement on that, okay, because you didn't have a trial, you didn't have the proper hearing on that, and you can also remind them that you have relinquished your signature on that, and therefore it cannot be used in your TPR hearing. That's the beauty of it when lawyers know what they're doing. That's why I work with lawyers, okay? But they'll try to say a parent is unfit because the house was dirty. Well, the house may not be dirty anymore. The parents may have been a hoarder, but they're not hoarders anymore. And it's true. I've had parents that were hoarders and had to help them clean their house out. I mean, you watch those TV shows, Hoarders. Yes, we have parents that are hoarders and children get taken because the parents are hoarders. Okay, that is an unsafe environment. Children should not have to live in that. And the parents need mental help, but with the Americans Disabilities Act, you cannot take their children from them if they go for treatment, clean their house. So when a juvenile officer tries to use the original petition in a TPR hearing, there is a way of getting that thrown out. Okay? There is a way. Okay? In the section 455, wait a minute, am I on the right page? Yeah. Section 455, child abuse or drug abuse before the child, or of specific conditions directly relating to the parent or the child relationship, either of which are determined by the court to be a duration or nature that renders the parent unable for the reasonable foreseeable future to care appropriately for the ongoing physical, mental, and emotional needs of the child. It is presumed that the parent is unfit to be a party to the parent-child relationship upon showing that, here we go, this is what they have to prove. Within a 3-year period immediately prior to the termination adjudication, the parental rights to one or more of the children were involuntarily terminated pursuant to Section 211.447, subsection 2 or 3, or Section 211.447, subdivisions 1, 2, 3, or 4. Now, I looked those up. Those are basically stating that when you know, a lot of parents, they get all upset because they terminated their rights. They didn't voluntarily terminate their rights. Their rights were taken on older children in their home, and then they get remarried 10 years later and have another child, and they get upset because CPS shows up and takes their newborn. Now, technically, they're not supposed to take the newborn if it's within a 3-year period, but the subsection 4, depending on the reason why your child was taken, the 2 or 3 or whatever children taken prior, if they had grounds, say, drugs or child endangerment, it depends on the charge on whether or not they can take your newborns. Okay? So when these parents are having babies after having their rights terminated, that's a bad idea. Okay, it's a very bad idea. Do not get with somebody who has lost their rights. If you're looking to, I don't know, and that's a terrible thing. Hey, are you a parent? Have you lost your rights? Because if you get with somebody that has lost their rights and you marry them, they can come legally and take your children, even though they're not his children. Why? Because you married him and he can't be around children, or she. Okay? If the parent is the birth mother and within 8 hours at the child's birth mother tests positive and over 0.08 blood alcohol content pursuant to the testing under Section 577 or positive for cocaine, heroin, methamphetamine, or controlled substances as defined in Section 195. Now, I want you to understand it is important if your child was taken at the hospital because of drugs, you need to get your records because they have a percentage of what your blood level is supposed to be in order for them to terminate your rights. A lot of parents don't understand that. They think, well, the child had born with it in their system. I understand that, but it has to be a certain level. They even put the amount that it has to be in order to terminate your rights. Details are important, okay? So make sure, a prescription drug should not be more than 196.973, excepting those controlled substances or prescribed drugs present in the mother's body as a result of medical treatment. Administered to the mother and to the birth mother is the biological mother at least one or other children who is adjudicated on abuse and neglected minor by the mother or the mother has previously failed to complete recommended treatment services by the Children's Division through a family-centered services case. So, if you have had children and they were born and you had previous children that were born with drugs in their system, they can come and try to take your newborn. But you have to understand you need to fight for your rights and you have to demand the amount levels. They are taking children on the ittiest bittiest amount levels and it's illegal. Okay? So you need to know what your rights are. Okay? And they don't like parents to be educated. Okay? They just don't like parents to be educated. They don't want people to know what's going on. If a parent is the birth mother and at the time of the child's birth or within 8 hours after a child's birth and the child tests positive for alcohol, cocaine, heroin, methamphetamine, or a controlled substance as defined in Section 195 or a prescription drug as defined in 196, except for those controlled substances that are prescribed. So a parent must have a prescription. These parents that are opioid addicts who used to be, claiming, well, I have a lot of pain, I need pain meds, but they are not prescribed, they have the legal right to take their children. Okay? If they are in so much pain, they must get a prescribed prescription. Okay? As a result of medical treatment administered to the mother, and the birth mother is the biological mother, you must have that prescription. Within a 3-year period immediately prior to the termination adjudication, the parent has pled guilty to or has been convicted of a felony involving the possession, distribution, or manufacturing of cocaine, heroin, methamphetamine, and the parent is the biological parent, at least one or other children who was adjudicated and abused or neglected minor by such a parent or such parent has previously failed to complete recommended treatment by the Children's Division. So if you're recommended, you don't have to sign a safety plan to do the recommended services. And I tell parents that. If they go and they get a court order to take your children from you, and you don't have to sign a safety plan, okay? You can literally say, you know what, I was wrong. I should not have drugs in my system, and I will go get clean. You must get clean right away. If you don't, and I have parents come to me, oh, I slipped up. I made a mistake. I was clean for 5 months and I had a relapse. You don't have the luxury to have a relapse. And I have parents that get mad at me when I say, well, I'm sorry, you're going to have to find guardianship because they're going to say that you can't do this. Your little relapse is going to cost you dearly. Okay? So that's why it's important, if you're an advocate, to let these parents know straight up, can't help you if you don't stay clean. Because if you don't stay clean, you don't have a choice but to voluntarily terminate your rights to a guardianship so that you can go get yourself clean and get your children back. Okay? So a juvenile court may terminate the rights of a parent to a child upon the petition filed by the juvenile officer or the division or to the adoption case by a prospective parent if the court finds that the termination is in the best interest of the child and when it appears by clear evidence. Okay, it has to be clear evidence. That's why gathering evidence is your best friend. Okay, when a parent is going into a TPR, they must gather all of their evidence, and we'll go over what evidence you need. Okay, I kind of gave a little video a couple of weeks ago, probably about a month and a half ago, of all of the evidence that you need. Okay, so the pursuant of 211.447.7, when considering whether to terminate the parent-child relationship, the court shall evaluate and make findings on the following factors. Okay, and I follow this to the T. Okay, when I am doing a TPR hearing, I get every state's what they have to present to the courts. Okay, and I prove otherwise. If you cannot, with beyond a shadow of a doubt, prove that you are not any of these things, then you have the right to fight for your kids. But if you are guilty of any of these things that I'm about to list, then you need to voluntarily terminate your rights to a guardian so that you can remedy this and then get your rights back. Okay? So, emotional ties to the birth parent. You need to have emotional ties to your children. Don't be one of those parents that show up at the visit and spend your whole time on your phone. Don't be one of those parents that show up and don't even acknowledge your kid's day. Okay, you have to show emotional support of your children. Okay, trust me, I've been on every angle of this. I've seen parents show up gambling on their phone during visits, won't even pay attention to their children, basically buy them Happy Meals and watch them play on the play place. That is not an emotional attachment. They're just there. Okay, that is not an emotional attachment. The extent to which the parent has maintained regular visitation or other contact with the child. You must not miss visits. If they are missing visits without being at a doctor's office or an excuse, they are screwed. Okay, no parent should missing visits. Period. If you are an advocate and you are helping people, that better be the first thing out of your mouth. Are you missing visits with your children? Well, yes, I don't have transportation. CPS won't help me get to my visit. Nah, wrong answer. Wrong. Okay? All right. The extent of payment by the parent for the cost of care and maintenance of the child when financially able to do so, including the time that the child is in custody of the division or the other child placing agency. So, what does this mean? That means you're providing services, providing for your children in visits. That means providing food, providing clothing, providing anything that they need, even while they're in care. So if your child needs a new pair of shoes, you're providing a new pair of shoes for your kids. Okay? You have to show that you can provide for your kids. If you don't have a job, you don't have income that's going to provide for your children, you need to be bringing stuff to your visit that provides for your children while they are in care. Okay? If you see that they need new clothes, get them new clothes. Does it have to be brand new clothes? No. Just as long as you are providing what your children needs. Okay? So a lot of times we'll be in a TPR hearing and the stupid caseworker will be like, she never showed, when she did show up for a visit, she wouldn't bring any food. It was meal time and she wouldn't bring any diapers for her baby. And the foster parents had to provide for her visit. She didn't even bring a birthday present for the child when they were, see how that just looks terrible, okay? So if you're not doing any of those things and you're not providing for your child, then you're going to have a hard time winning on your thing. Whether additional services would be likely to bring about lasting parental adjustment, enabling a return of the child to the parent within a substantial period of time. Now, what I like to do as a parent aid company, when I was a parent aid company, is, because I read all this. When I was a parent aid company, I was like, what can I do to help these parents? What can I help? Because they're looking at a TPR. My very first case, the parents were looking at a TPR and I didn't even know what it was. I had over 300 and something hours of visits with them with the understanding that it was reunification. And so I'm doing a visit, mom won't stop crying. I'm like, what's going on? I don't understand. You're having a good visit. Why all the waterworks? And of course I pulled her aside to talk to her and she's like, tomorrow's our TPR hearing. I said, what's a TPR hearing? I'd never heard of it. It was my first case. She goes, well, they're going to take our rights from us. I said, why? You've not missed a single visit. You've not this, you've not that. Oh, they're claiming my son was sexually abused because he sucked ketchup off a hot dog. And I'm like, what? He's not sexually abused. Where did they get that from? He's never been to a counselor, and I am 2 master's degrees. I work with children with trauma. That's what I do with my nonprofit. And I was like, your child's not been sexually abused. Not at all, okay? And I can testify as a professional witness of spending over 300 hours, I think it was like 323 hours, with your family and with this child. I can guarantee you beyond a shadow of a doubt, this child has never been sexually abused. Okay? And so I said, have your lawyer call me, and I'll be more than willing to testify. And I was on the stand for over 5.5 hours arguing with the juvenile officer whether or not this child had been sexually abused. And we won, because every argument that she had was ridiculous. Okay? And every time that I was going to blow her out of the water, I'd say, Your Honor, may I speak freely? And he'd be like, yep, that's what you're here for. And I would say, obviously, you have no idea about child psychology, or you're not a counselor, you're not a therapist, you have no idea. I said, when a child eats ketchup on ice cream, the simple thing is the child likes ketchup. So for him to be sucking ketchup off a hot dog doesn't mean that the child had been sexually abused. Okay? And then she was trying to say because he was in the process of potty training, he quit potty training. I said, children who are traumatized, especially, and I said, and in his visits, he always went potty on the potty. It was simply he did not want to do it in the facility that he was at because he did not feel comfortable. It had nothing to do with the fact that he had been sexually abused, okay? And he had had an examination and no evidence of it. And I had known that, talked to the foster parents about it, and even the foster parents agreed with me, who had had other children in their home that had been abused, that this child showed no signs of someone who had been sexually abused. Okay? So make sure to, if a parent has had accusations, that they have a professional witness on the stand to be able to make the arguments against a juvenile officer. Because you have to understand, you've got to understand that they're trying so desperate to prove a case against you with no actual professional witnesses. It's based on their caseworkers who are not licensed, against counselors who are paid to say what they are told to say. And so you need to bring in your own experts in a TPR hearing. Okay? So the conviction of a parent on felony offenses that the court finds is such a nature that the child be deprived of a stable home for a period of years, provided. However, that incarceration in itself cannot be grounds for terminating of parental rights. Okay? So, but what they're trying to say, if their parent's going to be in jail for 5 years, it's not in the best interest of a child to stay in foster care for 5 years. That's when a parent can voluntarily give up their rights to a guardian, a kinship, a friend, a church member, somebody that they trust. So when they get out, they can get their rights back. Okay? That's when I always encourage a parent, if you're going to jail, you need to voluntarily give up your rights to a guardian. Not adopt them, but to a guardian. Okay? Deliberate acts of the parent or acts of another in which the parent knew or should have known that the subjects the child to a substantial risk of physical or mental harm. So if a parent is married to a registered sex offender, and I've had this happen, please help me get my kids back, and then I find out they're married to a registered sex offender, they can and they will terminate your rights. You cannot be with a registered sex offender and think they're going to let you have your children. Okay? If you are deliberately putting your kids in harm's way by being married to somebody that has criminal offenses, criminal background, you risk losing your children. Okay? Considerations based on the child's best interest. Now, this is interesting. They always like to yell about the child's best interest, right? Well, they actually have rules and guidelines on what is a child's best interest, okay? And they act like, well, we all decided as a team that's not the best interest of the child. But they have rules and guidelines, even as a team, that they are must follow, okay? And I give all of this stuff to the lawyers when I work with them. The lawyers love it because they're like, I didn't realize there were rules and guidelines they have to follow. Yeah, they do. It's called a contract. They have to follow the contract and the rules and guidelines, okay? And they have statute codes that they must follow. So if you have a lawyer, I have won every single one of them. I have won every single one of them, okay, based on their argument of what is in the best interest of a child, okay? So, when considering whether to terminate a parent-child relationship, to the court shall consider all the relevant factors of the child's best interest, including, okay? Hold on one second, guys. Oh, I know I told her I was teaching a class today. I know she knows that. Okay, let me go back in. All right. So, consideration based on the child's best interest, okay? This is the thing that they throw out the most in a TPR hearing. So, write this down, okay? The emotional ties, the consideration is the emotional ties to the parents. They're going to say, well, Your Honor, they're not really, an emotional tie there. And they'll give out their arguments. The parent's not invested in the visits. She's missing visits. If she really wanted to have her children, she wouldn't be missing visits. Okay? The extent to which the parent maintained regular visitation. I know this sounds like it's a repeat, but it is a repeat. That's the beauty of it. They have to follow this. Okay? The extent of payment, whether they are providing for the child, whether additional services would be likely to be a lasting parent adjustment, the conviction of the parent, deliberate acts of a parent, okay? And then, and all they do is repeat that. Literally, the best interest of the child is the same reason why they take children. Why they determine whether or not they can terminate your rights. It's the exact same thing. Well, there's no connection. She missed visits. She didn't provide. She's married to somebody who may cause harm. Okay? So, they're all just repeated. Okay? So, the judge shall make the written findings in the facts and conclusion of the law. Okay? Section 211.444 allows the court to terminate parental rights of a child if it finds that the termination is in the best interest of the child and the parent has consented in writing to the termination. Paternity. It is imperative to identify any man or all men claiming interest in the child. Men having an interest could include alleged father, man named by the mother as a biological father of the child. Punitive father, man who claims to be the biological father of the child. If applicable, the married to the mother at the time the child is conceived. Of course, there's sections, subsections, and subsections of that, okay? Allows a person to make a referral to the juvenile offices for the determination of the parental rights, okay? The procedures for pursuing voluntary parental rights. This is the beauty. They try to tell you can't do that. They have a whole section where it says you can, okay? So when they argue with you that it is too late, a parent cannot voluntarily terminate their rights, they are lying to you. It is in their rules and guidelines that they can, and at any point in time. So let's go over the fact that they can, at any point in time, voluntarily give up their rights, okay? And it doesn't have to be for adoption. It can be for guardianship, and they get to pick, okay? That's the beauty of it. A request for voluntary termination of parental rights may arise in many different circumstances. It may come from expectant mothers who wish to place their infants up for adoption, or to their parents of one or more children. It may come from the parents involved in a child abuse neglect case. It may come from parents involved in a private child custody or child support cases. So, yes, even if your child is in Children's Division custody, you absolutely, and you can, put your children voluntarily up for guardianship. When a birth parent approaches the workers about executing a voluntary consent to termination of parental rights, the children's service worker shall determine the basis for the parent's request. The worker should inform the parents of the full range of alternatives for providing for the child, including services available through the Children's Division or other agencies and community resources. They're going to try everything they can to get you to sign a document saying, oh, I'll do all these services, and you'll help me get a house, and you'll help me do this. They won't help you do that. It's all a lie. The worker should explain to the birth parent that deciding whether to sign or sign consent to a TPR is a very significant step which has permanent legal, social consequences for the birth parents, the child, and the extended family. Okay? The worker should inform the parents that the worker is not given legal advice about whether or not the birth parent's legal interest to sign the consent to TPR form. The worker should advise the parent to consult with an attorney before the parents make a decision. So you can, parents, go to your appointed lawyer and say, I want to sign guardianship over to somebody else. You have that legal right at any point in time to do so. Okay? If a parent does not have an attorney, the worker should refer the parent to a legal aid office which covers the arena of any and other resources such as the Missouri Bar Laws Referral Service. A worker should carefully document in the record what information was provided to the parent and that the worker advised the parent to seek independent legal advice before signing the consent. The parent should be given significant time to carefully think through their decision and consult with an attorney. So when an attorney tells you, oh, you can't give guardianship to somebody else during the time that CPS has your kids, they're lying to you, okay? If the parent of the child is a minor or the worker has information which would indicate that the parent is under a disability, which may make it difficult for the parent to understand the legal and social consequences of signing a consent of termination of parental rights, the consent to termination of parental rights may be invalid unless additional procedures are followed. If any of these circumstances apply, the worker should refer the matter to DLS, the legal services, for procedures that may be appropriate. Once voluntarily relinquishment becomes the plan, the following steps should be completed. So there is a step, okay? Written consent forms authorized by the local juvenile court shall be completed and signed in accordance with court policy. It is preferable that the parent's attorney be present with the forms that are signed. So a parent can tell their lawyer, I want you to fill out temporary guardianship to this person, okay? They have that legal right. If a custody order is required, Follow local juvenile court requirements for obtaining one. Cooperate with the local juvenile court requirements for the letter, report, disposition appearances, and your testimonies. Collect parental background information, i.e., the religious, citizenship, immigration status, physical description, health, education. It is important to determine whether the child may have Native American ancestry and whether notice to the tribe is required by the federal laws. So there is the Indian Child Welfare Act. You can't do that. CPS can't even touch your case if you are with a tribe. Okay, so you need to make sure, do some DNA if you have to. If you fall under the Native American tribe, I tell people, bust your butt to get registered with your tribe, because CPS has to turn your kids over to the tribe, and the tribes are all about family. Okay? Once the case is concluded, obtain copy of any orders entered. Procedures for involuntary termination of parental rights. A plan for involuntary, that means they're going to force a parent to terminate their rights. When a parent does not want to terminate their rights, and they are going to force it, okay? A plan for involuntary termination of parental rights may be appropriate when there is a clear and convincing evidence that one or more of the specified legal grounds for filing a TPR exists in the case. Termination of parental rights is in the best interest of the child when the family support team determines that the child's best interest would be served by pursuing involuntary termination of parental rights. The family children's service worker should take the following steps. Now, the worker must do this, okay? Review termination of parental rights statutes. There's a statute, section 211.442 through 211.4487. And determine if the case information is consistent with TPR grounds for an involuntary action. In cases where the worker or supervisors are uncertain about whether there is a legal factual basis for filing a TPR petition, they should be referred to the case to the Division of Legal Services for a legal consultation through the DLS referral process. Children's Division workers should not be consulting the juvenile officer, juvenile officer's attorney, or the guardian ad litem, or any other private attorneys for legal advice. So if you've got a case where the guardian ad litem and the team all came to the conclusion it's illegal, they can't base it off of the guardian ad litem's recommendation or the juvenile officer's recommendation. It just said that, okay? Advise the parents of the decision, explore within the prospects of the voluntary relinquishment of their rights. So A, they can volunteer, but they don't tell you that, okay? Advise the parents of that decision. If the parent is represented by an attorney, the worker should not discuss the issue with the parent without first notifying the attorney and asking whether the attorney has any objection to the worker discussing the prospects of voluntarily relinquishment of their rights. If the attorney has obligations, when the worker should work through the attorney. The worker is represented by DLS. The worker should request the DLS attorney to initiate the process. If the parent does not have an attorney, the worker should refer the parents to a local legal service. Submit a written report in accordance with the local juvenile court policy. The family children's service worker should document. This is what the documents that they have to submit. Efforts expended to identify and locate the parents. So obviously if the parents aren't in the picture, they have to prove beyond a shadow of doubt they have tried to locate the parents. Okay? Alright? Services provided to each parent: intensive in-home services, drug and alcohol assessment, counseling, group meetings, parent aid services, family and or individual counseling, and parent training. They did not provide any of that. They are in breach of their contract. Okay? Response of parents to the services. Did the parents attend as required? Did the parent actively participate? Has the parent demonstrated improved abilities and skills as a result of these services? assessment of the child's needs, continuing a relationship with the birth parent, positive or negative for the child, prospects for adoption, and recommendation, even if more time or more services, parents will not in foreseeable future be in a position to assume care and custody of a child. What you need, baby? Can you turn this slide on over here? Receive written decision from the juvenile officer intend to file a TPR petition. Follow up with a letter requesting the decision, and written decision is not reviewed within 30 calendar days. So when you find out that you are facing a TPR petition, you need to follow up with a letter requesting that decision. Under what basis? You need to know what you're going into, what you're going to have to argue. Okay? So I definitely, when I take over a case, I ask for this letter. Okay? I actually demand it. All ordered evaluation reports shall be made available to the courts within 15 days prior to the dispositional hearing or as ordered by the courts. So the parents are allowed these documents. If they argue with you and say you're not allowed to have them, you need to bring this to their attention. They do, and they are required to do so. Assure the DLS attorney is unavailable to file the TPR petition. If the juvenile officer declines to file the petition for involuntary termination of parental rights, cases should be reviewed through supervisory channels. And if adoptive staffing has occurred, a family has been identified for the child, and there are no other competing petitions anticipated or filed, consult the family regarding their willingness to proceed with the petition for adoption and termination of parental rights. Here's the beauty. This adoptive staffing, if a parent has not been aware of that, they are trafficking your children. And so I always ask the parents to put into writing and request if there has been an adoptive staffing meeting. Because if they have that meeting without informing the parents, we can file child trafficking against the caseworker. And I have 3 here in Missouri right now because they had a adoption staffing meeting without the parents' knowledge. Okay? And they can't do that. It's illegal. Okay? A petition of involuntary termination of parental rights is filed by the Juvenile Court, Division of Legal Services, or the prospective adoptive parent's attorney, corporate with local juvenile court requirements, disposition appearances and testimonies. So the pursuant to section 210.145 and any judicial proceedings involving the custody of a child, the fact that a report may be made pursuant to sections 210 shall not be admissible. However, nothing in this subsection shall prohibit the introduction of evidence from independent sources to support the allegations that may have caused a report to have been made. This means that the fact that the division has substantiated a hotline report is not admissible in evidence as grounds to support a TPR petition. So, when they try to bring up the CS-13 or the reasons why your child was brought into care, according to this, they're not supposed to do that. They have to prove beyond a shadow of doubt that where you are today during this hearing, that you're not stable, that you cannot provide, that you are a drug addict or not a drug addict. They cannot use why your child was taken to start with. So this TPR hearing is not about why your child was taken into care. Okay? That's why those arguments about, well, they shouldn't have taken them to start with. Most likely they shouldn't have. Okay? But that's not your argument today. You're arguing today why you are the best fit, why you should not have your rights terminated, why you have done everything. And now, parents, you need to be honest. If you are missing visits and you are not providing and you do not have a job and you do not have stability, you need to sign guardianship over to somebody else. You do not have a chance in winning a TPR hearing. Okay? That argument that advocates use, oh, you know, if they didn't have the right to take your kids to start with, you have the right to win your TPR. It's not how that works, and you're not going to win. Okay? Now, the means, for example, the fact that the division may have a substantiated finding that a parent sexually abused the child is not admissible to prove the child was sexually abused. It is proper, however, for the party to plead and introduce evidence on the fact that the child was sexually abused from independent evidence such as child statements, witnesses, testimony, medical evidence from a counselor or a therapist. This provision of the law is to limit harassment reports. However, as a result, staff may be denied the ability to enter such evidence. If this becomes an issue, staff may be able to consult with a lawyer. Collect parental background information. In other words, all of the information whether or not the parent is stable, housing, religion, physical description, health, mental, education. One case is concluded, obtain copy of any orders entered. So you have the right to know any orders that have been entered on your case. So any court orders. Are you court ordered to do parent education? Are you court ordered to do drug testing? Are you court ordered? If you are court ordered, you must do it. If you do not do your court ordered items, CPS cannot hold things that are not court ordered against you. Okay? So if you are not court ordered to do parent education, they cannot hold that against you. Though I do recommend that parents go ahead and do it, but that is not an excuse for them to TPR your rights if it is not court ordered. Okay? So you need to know what the court orders are. Okay? You need to demand to see what the court orders are. Okay? And make sure that you are doing your court ordered services. That means you don't necessarily have to sign for it, but the judge says, hey, you need to go do drug testing once a week, twice a week, whatever. Hair test once a month, twice a month, whatever. You do the court orders. You have to. You are not at liberty to just pick and choose what you do and what you do not do. Okay? TPR granted. If the courts grant a TPR, the Children's Division must implement a permanency plan. Okay? That means that the adoption should not have been decided before the TPR hearing. So I have cases on these 11 cases that I won where 3 of them, the adoptive family was waiting in the waiting room to take custody of that child that day because they had already done the staffing and all of that before the TPR. And that's child trafficking, people. And if you know that, you can file charges. Okay? TPR not granted. If the court denies the petition, the worker should evaluate the reasons the court have given the denial and take appropriate action, including reevaluating the permanency plan for the child. The worker should promptly schedule an FST to determine an appropriate case plan. So, in other words, they're trying to give them a back door if they lose. Okay? Such discussions in the FST should include the evaluation appropriateness of the concurrent plan. If the court denies the petition, the child was in the custody of the Children's Division. The division may have the right to appeal the decision of the Court of Appeals or to the Supreme Court. So when these CPS workers basically think they rule and can do whatever they want, they can't. They have to, and a lot of times will win because they think they can just, be in contempt of court orders. We wait past the 40 days. If they don't appeal within 40 days, they have to return the child. Okay? So, an appeal must be filed within 40 days of the date of the court's order denying the petition. Okay? To pursue an appeal, the Division of Legal Services must prepare and submit a referral to the Attorney General's office. If the division wishes to consider pursuing an appeal, the division must refer the matter to DLS no later than 10 days from the date of entry of the court's order. So if the appeal is not filed within the court in a timely manner, the judgment becomes final and in most circumstances cannot be appealed further. So you need to make sure that if they lose, that if they don't appeal within 10 days of that judgment, they can't. So what they try to do is when they lose and they don't meet that appeal, they try to reopen a new case. They can't do that. it says that they cannot, becomes final in most circumstances, cannot be appealed further. So it costs the assessment, such as attorney fees against the division. Payment must be processed within 30 days. If there is a question whether the court has the authority to assess the costs or attorney fees against the division, or whether the amount charged to the division is reasonable to the worker, should initiate a referral for legal advice. The court rules imposes time limits on the ability of the division to challenge such orders once they are entered. In most cases, challenges must be filed within the courts within 30 days of the date of the entry of the court orders. The worker and the supervisor must therefore possess such DLS referrals on an expedited basis. Okay? Termination of parental rights referral form. There's actually a referral form. Okay? And I like to download, and I brought up what's called the Termination of Parental Rights, how to appeal. Okay? I like this. I go by it. And I really believe that, now this was written in 2005, but I liked how this lawyer pieced it together. I like how the statements, he wrote this really well. I was really impressed by it. I use it when I am helping parents gather their evidence, when I'm helping parents proceed with trying to appeal their cases. Okay? And the parents a lot of times wait the last minute. And I don't know why they do that, but they do. They'll call me a week before their TPR hearing. Oh, I'm going to lose my hearing. Yeah, you are. I'm just honest with them. I say you either get a continuance or you do a guardianship or be prepared to appeal. I've had parents not even show up at their TPR hearing because they overslept. Okay? You can't do that. You're screwed. Now, can you appeal it? Yeah, but they're going to say, look, you couldn't even come to your hearing because you overslept something that important. Come on, guys. That doesn't show that you can be a parent. What if there was an emergency? Okay? All right, so this article is a perfecting the appeal in the termination of parental rights case. So if you lose, you go into there and you have, so I tell my parents, document everything. I love the idea that we have great technology today. There's great apps on people's phones. Now, each phone services have different kinds of apps. Mine, I have an iPhone, so I have different apps than someone has, these other services. So, but I have things like DocuSign, Sign Easy. Let's see, there's some other ones. But those are the two that I like to use. They're literally like $9 a month. Unlimited signatures, unlimited forms, and all this stuff. So what I do is I help the parents create a sign-in sheet for parent education, sign-in sheets for counseling, sign-in sheets for drug testing, sign sheets for even going to work, because caseworkers will accuse them of not even going to work, claiming that they tell them they work, but they don't work. Okay? So I have parents. So the beauty of this technology is you can bring it up on your phone, right? And say you're going to parent education. You get the instructor to take the phone, put their thumbprint on the phone. It GPSs the location, snaps a picture of the person, the instructor, and it makes it a legal document. Okay? So I taught these parents who came to me wanting to fight their TPRs to prove beyond a shadow of a doubt that they were doing their services. Because what happens is when you go into court, the first thing out of CPS's mouth is, Your Honor, he didn't do any of the services. She didn't do any of the services. And they're lying. They're lying through their teeth. Okay? Because they didn't bother to go and get the logs from all your parent education, from your drug testing, from your whatever you have to do for services, whether it's domestic violence classes or domestic violence counseling, whatever you do, have them timestamp it, So I also tell my parents if they have children who are, say, autistic or have disabilities, to go and take extra classes. They give free classes like at the local um, children's hospitals. They do autism classes, they do ADHD classes, they do first aid classes, they do CPR classes. Even if it's a small fee like $5, $10, $12, I tell the parents take those classes. Again, have them sign, get certifications, get your certifications, and make sure that you provide that when you go to court on the date of your hearing. Now, these lawyers will not do the work for you. Okay? These lawyers who are supposed to fight for you should be gathering this information from you, but they're not. Why? Because they go in there and they wing it. They literally go in there and wing it. What do? They meet with you 1 hour before the hearing and they wing it. Okay? So you as a parent, you as an advocate must help the parents gather all of their evidence. So they need to show stability. That means their power bills, their water bills, their phone bills, any medical that they have to pay. Anything that you can show that they're being stable in. Now, does it mean if they're late on a payment, as long as it's being paid, that's all it has to show. Okay? Also, you need to have, if they have SSI or disability, they have to prove beyond a shadow of a doubt that they can support their children on the income that they get from their disability. Okay? So these parents that are renting out their kid's bedroom can't be doing that showing up at a TPR hearing. When they go to a TPR hearing, they need to have their children's pictures of their rooms, their beds made, their clothes, their shoes, their dressers. They need to show that they have food in the home that they can provide. All of this is very important. You wouldn't think you'd have to do that, but the whole idea is they got to prove beyond a shadow of a doubt that you are not doing services. And if you come in there with the evidence that you have, I had a parent who was 19 years old when we started parent aid services with her when she was 17. We helped her get her GED, taught her how to drive, go to hair school, helped her get her first vehicle, get into her first apartment, get out of that apartment, get into a rent-to-own apartment once she started her business as a hairdresser, and helped her get her first business up and going, helped her get certified in autism classes, helped her do all her parenting education. She was clean for 2 years, okay? And her drug of choice, literally, a 17-year-old, it was weed, but it wasn't legal. So they were trying to take her kid because she had weed in her system when the baby was born. And it wasn't in the amount that they claimed it had to be, okay? But she was a product of the system, and so they were just taking her kid because she was a product of the system, and she didn't know what to do. Okay? They were trying so desperately to take her baby. And we taught her how to document everything, and sure enough, when she went in for her TPR hearing, the first thing out of that guardian ad litem's mouth, first thing out of that caseworker's mouth is, Your Honor, she didn't do any of the services. Wrong! She did. We have all of the evidence. And so what I like to do is I create what's called court folders. Okay? I make 10. Okay? I've got the judge, the lawyers, the guardian ad litems, her assistant, your lawyer, one for you to follow with, and extras. The clerk might need one. You always have extras, so I always do 10. Okay? Because what will happen is if you just bring one folder, okay, they'll say, oh, the printer's broke down. I've had them do that. The printer's broke down. We can't enter this into evidence because there's not enough for everybody to have a copy. You don't want that to happen, okay? So you need to make sure that you have copies of everything, okay? You have copies of your psych evals, your medical records, your children's medical records. Now, remember what I told you at the beginning of the class. that if you go to your doctor's office and try to request your children's medical records, and they say, we're sorry, we can't give that to you, you'll have to go through CPS. You say, give me my HIPAA form that relinquishes my signature. You relinquish your signature in that, and then you hand it back to them, and you say, give me my records now. They just, oh, give me a few minutes. They go back there and they talk. They come forward and they go, no, I relinquished my signature. See, even Children's Division can no longer have my records. I want my records now. They will give you your records. They are required because HIPAA is federal, not state. Okay? They can be fined $10,000 if they refuse to give you your medical records. I've had this happen many times. And yes, you have to be firm. Be polite. Don't let them call the police on you. But be firm that you're not going to leave until you get your records. Okay? They'll try to do this number where, oh, we need time to get your records. No, you don't. It's in the computer. Print it out. Okay? I want my child's records. I want all of the records. The doctor's notes, the counselor's notes, not just the visits. I want the notes, the diagnosis, everything. Okay? You want to go get, if you are prescribed medication and they're trying to say that you are taking meds that you are not prescribed, you make sure that you go back 5 years to wherever you go to have your meds prescribed and get your prescriptions of every med that you've ever been prescribed. Because I don't know about you, but I save meds sometimes, like especially like if I had a tooth pulled and I have some extra painkiller and something happens and I'm in so much pain, I take a painkiller that I had when I had a tooth extraction. I was prescribed that prescription. It's my prescription. And if I choose to take a painkiller 3 years later, it's probably not the best and not the best dosage. It's probably out of date, but it's still my prescription. Okay? And I can prove that it was my prescription. See where I'm going? They're going to try to say that the parent, and I've had parents do that, say, well, I had a prescription for a painkiller. Okay? But you have to prove that it was your bottle that you took the prescription from. Okay? And I always keep my prescriptions locked up. You know, if you're a parent and you're having to have prescriptions for painkillers and stuff like that, you should be responsible enough to keep it in a locked box or cabinet. You don't want your children to get a hold of that. It's important that you don't do that. And you want to document everything to the point where you're documenting your work schedule. You're documenting money that you make on the side. Now, a lot of parents who are on SSI don't make enough money. Okay? So, you want to be able to prove beyond a shadow of doubt that you can provide for your children. Right? So, it's expensive to raise children. So, with that, you must prove to the courts that you will be able to provide educational services for them. So, you need to go to the school that your children will attend, and get a roster of everything that they can provide for your children. That is part of your evidence that you can provide where you live for the needs of your child. So, if your child is autistic, does your local school provide autism classes that are paid through the Medicaid? Because then they'll say, well, he has special needs. Yes, he does. And I've already can present to you a plan, your own plan, and how you're going to care for your child. Okay, so if you have a child that has special needs, you need to show the courts that you have taken the steps to know how you're going to provide for that child's special needs. Okay? I know it's just a lot of information, and by the time you're done with you've got a file probably that thick, okay, by the time you go to court. And you have copies of 10 of these files. And when you show up and you pull the lawyer in and you say, I want all of this submitted for my TPR hearing, he'll look at you and go, what is all this? And you say, it's my evidence that I'm stable, that I pay my utilities, that I am no longer a drug addict, I've been clean, here's all of my drug tests. Now, they try to say that you can't get your drug test. Same principle. The reason they tell you can't get your drug test because CPS ordered it. But you signed a medical release stating that CPS can get your results. So again, All you have to do is relinquish your signature and get your own drug tests. Okay? So that argument does not stand. Okay? And a lot of CPS workers will go, why did you do that? Why? Because now they can't get the records. They have to get them from you. Okay? And provide those records. And have proof that you provided it. Every email, I teach parents, document, 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 document. Now, remember, caseworkers' emails recycle, here in Missouri, it's 72 hours. So, if you have a very important email and you think it's something that's important, take a screenshot of it. Save it in your cloud, because those emails will disappear. And then they can claim, why? I never received an email. I didn't ever receive this. I didn't receive that. I have proof of it. You absolutely did. Now, a lot of the arguments that I get with lawyers is it's hearsay. Well, I actually taught a class on what hearsay is. Okay? Hearsay is it's a reasonable doubt, right? Basically, it's a reasonable doubt. So what you have to do when you want to prove something beyond a shadow of a doubt, you have to put that person on the stand. Say it's a caseworker, okay? And she's lying, claiming that she didn't receive this, didn't receive that, okay? So what you do is you put the caseworker on the stand, and I have the parents write out the questions for the lawyer to ask. What is your name? What is your birthday? What is your address? Do you have your ID on you today so that we can confirm that this is you? And I know that seems like a strange question, but yes, those are one of the questions I ask. And they'll say, yes, I have my ID. Your Honor, I'd like to see her ID. Why? Well, I want to confirm she is who she says she is. We want to make sure, Your Honor. All right? So we get her ID. Okay? Then we ask her, is this your phone number? And you give her a phone number. Are there any other numbers that you use with your business, with Children's Division? If so, would you please tell us those numbers? Okay? Then, what are your emails that you use for Children's Division? Is this your email? And you confirm the email. You confirm the email, you confirm the phone number, and then you confirm whether or not that phone number can receive text messages. Right? You're establishing no longer hearsay. Okay, you are establishing that she is acknowledging who she is, and then you ask the question. The other question, does anybody have permission or access to use that phone number and that email? And the answer is always no. No, nobody has access to that phone number. Nobody has access to that email. Perfect. We have just established, Your Honor, who this person is, who this person's email is, who this person's phone number is, and now, Your Honor, I'd like to enter this evidence of emails where the caseworker claims she never received this, and we have evidence that she did. As you can see, Your Honor, the email that she herself, just 2 minutes prior, stated was her email, and only she can receive, and only she can, and you can tell if an email's been read or not. Okay? She claims she never received. On this date, this time, she did receive it and opened it. Whether or not she read it, we can't establish that. But the fact is, it's her email. Only her opened it, according to her own mouth. Therefore, it is not hearsay. See how that works? Lawyers love it. They're like, oh my gosh, that is not hearsay. No, it's not. Not when they establish who they are, what their numbers are, what their emails are. And some caseworkers have more than one email. Okay? And so you need to ask them, are there any other emails that you connect with clients with? Okay? It's important. Because if they do use other emails, you want to establish what those emails are. Okay? Because if they try to say that they emailed you, you can argue hearsay as well. Okay? And because they didn't put you on the stand and then they did not confirm that was your email. Okay? That's how you can argue the hearsay. Okay? So, I also want to let you know that the Children's Division are required to meet certain standards. Okay, so you're going to want to print out these different things for your lawyer. So I always print out for the lawyer the section 4, chapter. I print the whole thing for them. What I just read to you is it's called the Child Welfare Manual. Okay, it's their actual manual, their rules and guidelines for a TPR. And what we do is I require them to bring the supervisor, the caseworkers, the guardian ad litem. If they're not there, then we can't have a TPR, Your Honor. Why? Because they have to have recommendation from the family team. And if they're not there, how can we question them? Okay? So I also like when we put the caseworkers on the stand, I also have the lawyer ask these questions. What is your education? Where did you go to school? What is your license? Well, I don't have a license. Oh, so you don't have a license. You're not a counselor. You're not a therapist. No, I'm not. Oh, okay. Well, if you're not a licensed counselor, you're not a licensed therapist. If you're not a doctor, if you are not, what are you? Oh, you're a case manager. That's it. You're not even a licensed social worker, which means you do not have the qualifications, okay? You have no qualifications for being able to make this opinion. They hate that. It makes them squirm in their chairs. They can't stand it because you make them look like a fool, okay? Because when they argue, well, Your Honor, the mother is mentally unfit. Really? In your opinion, the mother is mentally unfit. Well, Your Honor, we've already established she doesn't have a license. She's not a counselor. She's not a therapist. Her opinion doesn't matter. Literally, her opinion does not matter. She is not qualified to make that decision. She's nothing more than a case manager. And a case manager, what is the definition? And I always look it up in the Child Welfare Manual. What is the definition of a case manager? Case manager sets up parent education, services, but they don't provide the services. All they do is set them up. So if the parent is getting services, it's not whether or not the caseworker can determine. See, they like to use this determination a lot of times on some of the cases. Well, we don't agree with the counselor's assessment. Really? Are you a licensed counselor? Well, no. Well, then how does your opinion matter? I piss them off every single time. And I'm not the lawyer. I practice with the lawyers. This is what you need to present, and I want it asked this way. I want it done this way. And these lawyers are like, man, I've never seen anything like this. I've had lawyers pay me just to sit in court to intimidate CPS because they expect me to get on the stand, and I'm not. They have no intentions of putting me on the stand. I'm just sitting there with my notebook taking notes. A lot of times I'm just doodling. Why? Because I show that they are nothing. They're nobodies. They're literally nobody. Now, the supervisor may have a license. May. I actually had a supervisor who had lost her license. Okay? And when we questioned her about that, why did you lose your license? Like I didn't research why she lost her license. Of course, she lied on the stand. Oh, Your Honor, we'd like to present the reasons why she lost her license. And here she is working for a children's division, making decisions on children's division when she lost her license, did not renew her license because she can't renew her license. Yeah, that didn't go well. Needless to say, she quit that day because I embarrassed her. She should be embarrassed. She should not be working in the field, taking children away from their parents when she's not qualified to do so. Okay? And it was proven over and over and over again this woman did everything she could to retaliate against these parents. Okay? So parents, if you are fighting a TPR, do everything in your power to do all of the services. Okay, if you are having to do counseling, therapy, psych eval, get your own psych eval. That's the beauty of being able to dispute when, because I get a lawyer to dispute, are you paid by Children's Division? Because I'll put the counselor on the stand and I ask them the same thing. What's your name? What's your address? What's your credentials? We found out in one of the cases in Florida, when we put the counselor on the line, I let him know he's going to lose his job if he stands there and says the parent is incapable of having her child. And he was so confident, and he was like, oh, yeah, yeah, yeah. My word is gold. They listen to me. And I'm like, okay, you want to play that game? Let's play that game. See you in court. Plus, I already knew who he was. I already knew I was going to cost him his license. I cost him his whole practice. Okay? He'll never practice again unless he goes overseas or something. I don't know. But anyways, he was a foot doctor. He wasn't even a psychologist. Yet he was being hired by Children's Division to be a psychologist. Okay? So, when you are working with a TPR, you need to find out everybody on your case. You need to find out who the caseworker is. Are they licensed? It is listed on their state agency whether or not they are licensed. You need to know whether or not your caseworker is licensed. Okay? Where did they go to school at? What is their education? It's all listed. Okay? You need to find out. Uh-oh, my battery's about to die. You need to find out your counselors. Are there reviews online that are very negative against them? You need to know who you're dealing with. Okay? And you might be surprised that they have no legal grounds to even be making those observations for Children's Division. Now, I had a grandparent lawyer hire me to look over some psychiatric evaluations on 2 boys, and I found so much fraud from this psychiatrist because she was copying and pasting. She had these children in care for like 2 years, and she copied and pasted every single report in each of the boys' reports, which is illegal, by the way. You cannot do that. And every statement that supposedly the one boy made, the other boy made. And I'm like, so what? They're identical twins? And they weren't identical twins. But why are her reports identical? Because she didn't do her job. It was a copy and paste psychiatrist who would do and say whatever Children's Division told her to do and say. And so she would copy and paste and didn't realize somebody was going to be reading this. Okay? Because I read everything. I think the folder was a good 6-8 inches thick. I read every single page and I was like, this is repeat. Why is this repeat? And then I realized what she had done. Okay, all she did was change the name and the birth dates on every report. Is all she had done. So it made me wonder how many other reports did she do that to? And I was going to expose her. I mean, my book was thick. And I had written on the front of it, fraud, fraud, fraud. It was wonderful. I was waiting all day, 8 hours. But they gave the kids back because they were like, don't put her on the stand. If you put her on the stand and she testifies against this psychiatrist about fraud, every single case that she's ever been on, and she has used 92% on all of their cases, every single case would have been investigated. And so they gagged me where I couldn't get on the stand and testify that she's a fraud. She was a fraud. So they made a deal. We'll give the kids back if you don't put her on the stand and testify. I'm like, get your kids back. Get your kids back. I don't have to testify. She will be found out. She will. I just have to wait a year, and then I'm going to submit it to her board. I love it. So she's not out of the woods yet, because I will be testifying against her on medical fraud. So I intend to file the whole thing within a year against her. So that's what I intend to do. So anyways, are we got any questions so far? Guys? Are y'all asleep? Am I still got viewers? It says I have 3 viewers. I'm assuming it's Julie, Nora, Who else is here? Did I lose you guys? Jody, are you here? Or Janine? Who's all here? Do not fight with CPS about it. Get your lawyer to do it. Exactly. Get your lawyer to do it, okay? That's why I work with lawyers. A lot of people say, but I got a court-appointed lawyer. Every single case, guys, that I have ever won, I've had a court-appointed lawyer, okay? Every single time. Why? Because I make them do their job. Literally. I print out the rule books and I say, you got to do this and this and this and this, and if you don't, I'll have your license. Plain and simple. And I've gotten 2 lawyers debarred. I got 1 lawyer debarred twice. Not very happy with me, but I'm okay with that. The problem is parents, and I'm sorry that you're going through this, are just not educated in how to fight CPS. And so they trust that CPS is doing the right thing and don't even realize they're being screwed by CPS. They have no idea what their rights are, that they could have voluntarily terminated their rights at the very beginning to a family member without CPS even really getting involved. Within that 72-hour hearing, you can literally, and I've had this too. I've done this many times. I've had a kid taken. I get called, Miss Grace, what can we do? I say, you get a family member to file and intervene and be at that court hearing, at the 72-hour court hearing with that petition. I help the parents fight the petition, fight the intervene so that the kids are not in foster care, but they are given to kinship, and they have to follow the rules of kinship. And if a kinship steps forward within that 72 hours, they have to consider that kinship. Now, they want to argue and say, but we got to check out the house and we got to... No, you don't. You absolutely do not, because they're kinship. You have no grounds whatsoever to say that this person is not fit to have this child. And if the parent wants to give guardianship to them, if you want to do a home inspection, fine. But you can do it after you return the children to the kinship. Okay? So I always try to get the kinship before that 72 hours to try and get a well visit from a police officer. And a lot of people get pissed off that I do this. I'll say, I need a well visit at my house. Why? Well, I need it for court. I need to know that my home is stable. And so you call the police and you get a police report. I have the guardian get a police report that their house is stable and that there's no concerns. Because CPS likes to do this thing of, well, we don't know that it's a fit home. Well, Your Honor, I already got a police report right here that says that I have no problems at my house and everything looks fine. And I have a well check at my house. My house is fine. They get mad. They don't expect that. Because CPS are contractors. They got to get that parent to sign. They will, I don't know, I worked my butt off on this case, proven beyond a shadow of a doubt that everything in their petition was nonsense. Literally, it was nonsense. Okay? But they got this mom separated from me, pulled her into a room, told her that if she did not sign and agree to a safety plan, she would not get visits. And I had warned her, don't sign anything. Don't agree to anything. You go to trial. Even the father's lawyer said, this is awesome. They have no evidence against you. You could totally win. Even the father's attorney was like, this is cool. They have no evidence against you. Even in their petition, it's all nonsense. Don't sign anything. And what does the mother do? She goes and signs. And now she's fighting for her children because she signed the safety plan after I told her not to. You know what I do when parents don't listen to me? I'm done. You don't want to listen. You want to do it your own way. Fine. Do it your way and see how that works for you. Because the second you sign, you admit beyond a shadow of a doubt that you need to have your kids in care. and you have signed their contract. Okay? Can't be doing that and think that you're going to win. Okay? You literally cannot be sitting there. And as I'm sitting there watching this, they even asked the parent, were you persuaded by anybody? And I was like, tell them that they threatened to take your visits away from you. Miss Pennington, do you have something to say? And I'm like, yeah, I do. She should be speaking up. Well, nothing you say in here can be, construed as, you're not a lawyer, you're not. And I'm like, this is bull. This is bull. I got up and walked out. Got up and walked out because the parents sat there and said, no, we were not coerced. No, we were not threatened. No, they said that on record. No, we were not coerced. No, we were not threatened. They were coerced. They were threatened to sign that safety plan. And they should have said so on record. They should have said so on record. And that's why it's hard to fight them once you sign that safety plan, once you do not demand that trial, once you demand to have proof and evidence. I had Jamie's case, the breech baby case. They offered her 17 safety plans. I said, the second you sign it, Jamie, I'm gone. Because I know for a fact that you can win. I know for a fact at the trial you'll be able to win. If you sign that safety plan, they got you for at least a year. Don't sign it. She was 5 months in her case when they had to call and say, come get your kids. Trial has been dropped. Your kids have been returned. We have no case. I knew they had no case. And I knew the reason they were off, and they would beg her, you sign this today, we will bring your kids right this minute. I'm like, don't do it. They will bring them and then take them back the next day. I've seen that happen. Sign it, they'll bring your kids and then come back the next day saying, oh, we got concerns. Okay? And because you signed it, they can do that. And parents are told to sign, oh, we won't take your kids if you sign this, right? I don't know how many times I've had parents tell me, if you sign this, we won't take your kids, right? 2-3 days later, they're showing up taking their kids because, oh, they missed too many days in school, or, oh, you forgot to pick up some prescription at Walmart, or you didn't give your kids Flonase when it was a PRN as needed, and they didn't need it, so you didn't pick it up. See what I'm saying? And so they'll look for any excuse to say, oh, we really, you signed already. We feel that there's a concern, so we're going to come take the kids. See how that works? Tell your clients, don't sign. And if they have signed, they need to relinquish, take back their signatures, okay? Because they signed under duress. And that's why they would, under the affidavit, that's what they would write. I was under duress and signed this. Now that I'm no longer under duress, I relinquish any signatures for anything. Medical, school, any records at all. They'll even get your military records. They'll, whatever records they want when you sign that medical release. They'll go back to your high school teacher and talk to your counselor in school. I had a parent, when she was she's a grown adult, but they actually got her records all the way back when she was 14 at a school counselor, where she said she snuck out of the house to go get drunk. And then all of a sudden she had to start doing drug and alcohol counseling and therapy and tests for alcohol when she wasn't even alcoholic. She said that when she was 14. Why the heck would you make her do all that when she doesn't even drink? She told you when she was 14 she snuck out of the house to a party and got drunk. They were using things in reports that she had stated when she was 14 years old. And this mom was in her 30s. That's how ridiculous and how desperate they were to find anything and anything that they could. Okay? And it's sad that that's what they do, but um, it's unfortunate that they do that. Okay? And that's when you relinquish all signatures. You relinquish any medical records that they have. Because if you relinquish all the medical records that they have, they can't use them against you. That's why they get mad at you when you relinquish your signatures. They'll be like, why did you do that? Why would you do that? Again, it's not legal advice. I'm just telling you what I would do. Okay? So I have time for question and answers. Anybody want to go over anything that I have missed? You have any questions at all on the process and how to do this TPR hearing? Now, we can look up, and I was going to have, but I realized we've got people from different states. What I teach here in Missouri isn't necessarily going to apply to every single state. So, the first thing you're going to want to do, for recap, guys, is bring up the Child Welfare Manual for your state and their TPR rules. Okay? You want to get a copy of that for everybody. The lawyers, the judge, all of that. Why? Because they probably have never seen it. Judges probably never seen it. Okay? They rely on CPS to tell them the rules and guidelines. Okay? So you need to print out the rules and guidelines for your state. That's where I start. Okay? Then I make sure the parents are doing all of their services. They document all of their services. They go back and get all their services documented if they haven't been keeping up with their documents. And then make folders for everybody for the lawyer. You also print out your state's court's guidelines on what your lawyers are required to do. They work for you. Okay? So if you tell them you want to put in an evidence, a stool sample, by golly, they got to submit your stool sample. That's what they want, if that's what you want. Okay? Just using an example. Okay? Okay, so we have a question here. I have a question on a court order that's length. Can I email it with documents? I have a question on a court order. Oh, it's lengthy and you want to email it to me? Is that what you're asking, Miss Crystal? I'm more than happy to answer any questions. Or anybody who attended the class today, I'm offering 2 hours of free consultations to you. And my phone is open to you guys. So if you have questions or you need some help on a case or anything like that, if you attended here, I've got your names down. Miss Janine Lyric, Crystal Reagan. Yes, I'm more than happy, Crystal, to look at it. But remember, I'm not a lawyer, but I'm more than happy to give my opinion on it. You may ask what my qualifications are. I think 2 master's degrees. I've authored 4 books on the subject. I've closed 178 cases, reunited 418 children back to their families. I have 12 credits away from a doctorate. That, I'm not a lawyer. I study. I probably know more than a lawyer, but I am not a lawyer. Okay? I'll be in touch with you. Okay, so my email, guys, let me type it in the here, I'm trying to hold my phone here. Hold on. So my email, oops, can't spell today. Okay, so if I don't respond to that email, you can send it to this one. Sometimes, somehow I get shadow banned and emails do not come through. So there's 2 emails that you can use, okay? If for some reason I don't respond, it's because I don't see the email. So sometimes some of my emails don't come through. I'm not sure why that happens, or how they are able to block them. So I usually don't miss any emails if you send it to the GHFC Pennington one. But they shadow ban the Lucinda Grace Pennington one. So if for some reason I don't respond, go ahead and send it to that one. Okay? Okay, so Ohio, I have actually, I think, 3 cases out of Ohio I've helped return children. I had one case that had been open 3 years. I got it closed in less than 2 days. I'm like, on what grounds do you? I mean, the kids are at home. You've already returned the kids. Why do you think you can just willy nilly just keep a case open? You can't do that. You need to close this case. You have no grounds. The mom wasn't charged with anything. She relinquished. She's never signed anything. You can't just keep this case open. And when I challenged them on that, next thing we know, we're getting, we just got to do a walkthrough and the case is closed. Yeah, I thought so. And so what I did was, well, because of COVID, you're not going to go in the home. We will do a Zoom with you, and I'm going to be in the Zoom. I'm in Missouri. She's in Ohio. I said, we're going to do a Zoom with you, and since it's COVID, since I already got the email saying you're going to close the case, we're going to do a real quick walkthrough, and you're going to close the case. Because if you don't, I'm going to press charges against your agency for keeping a case open illegally. Okay, simply for money. Okay, there were no grounds whatsoever. We had letters from the school that says the mom was doing everything she was supposed to in school. She was meeting all of their IEP needs. There was no concerns with her counselor, no concerns with, her charges were dropped. There were no reasons why CPS was still involved in her life. 3 days later, case closed. It'd been open 3 years. She had her kids for 2. And they just wanted to keep it open. Keep it open. Keep it open. I'm like, you can't. You're illegal. You cannot keep this case open. Okay? So, it always merits knowing their contract. Now, the state of Missouri's contract, I printed it in an 8x10. It's literally 879 pages. Small print because I couldn't fit it in it. I couldn't do more than 880 pages. So I had to shrink it so that you could read it. Their rules were so extensive, okay? But if you know, and it's funny because I've had them put the supervisor on the stand and I will have the lawyer submit the rules and guidelines. And they'll sit there and we'll say, are you aware that your rules and guidelines state this? And they'll be like, what? It's like a deer in a headlight. What? What are you talking about? Oh, Your Honor, we'd like to show you their rules and guidelines on their own website, right? Page such and such, chapter such and such, section 4, chapter 6, subsection 3. We would like to show this to the supervisor to let her know that she's in breach of her own contract. But she can't do that. She can't up and decide on her own what she can and cannot do. And they sit there and go, I've never seen this. I don't know about this. Well, Your Honor, it's their rules and guidelines. You're telling me the supervisor doesn't know the rules and guidelines at Children's Division? Sounds to me like she needs more education on the rules and guidelines that Children's Division is to follow. I'd make a really good lawyer. The problem is they won't let me go back to school. I owe too much on student loans. So I've been crash learning law without a license, sitting in classes. I can sit in classes and learn, but I cannot get my degree, law degree. I thought about, there are, I think, 5 states that you do not have to have a law degree. You just have to pass the bar to be able to practice in those states. I think it's California, Massachusetts, Virginia. I think it's 5. I can't remember what states they are. But I've thought about taking their bar exam in all of 5 of those states to see if I couldn't practice law in all 5 of those states and start helping these families in those 5 states. That was an idea. I don't know. I have test anxiety. I don't know if I could pass the bar, but I do know a lot about law. Family law, but not about all kinds of law. And I don't know what the bar kind of law exams do, but I've thought about doing that. But unfortunately, this is the last class I will be teaching when it deals with Children's Division, as I am moving on to help young adults that are aging out of the foster system I am, Lord willing, next 2 weeks, be signing a contract on a property in Archie, Missouri, where I'll be able to house young adults who are dealing with Children's Division and young adults who have aged out of the system, who are possibly pregnant. It's not necessarily just women. I'll have two properties, one for men, one for women. And that's what I'm going to focus on. I am going to focus on helping these young adults be successful and get CPS out of their lives. And so I'm not going to focus so much, but I'm more than willing to help those that attend this class today. Alabama, Ohio, Janine, Lyric, Crystal, Reagan. Of course, I've helped Julie Martin already. Are you still here, Miss Julie? I'm still going to be helping Miss Jody Hibden. I know her. Julie Martin knows I can help. I've helped her get her grandbabies. But I work with lawyers, and I help fight the system with their own rules and guidelines. Now, do they always follow their own rules and guidelines? Nope, they sure don't. And that's when you sue them with torts. Torts are a whole nother thing. When I discovered those, I was like, this is brilliant. You prove beyond a shadow of a doubt they do not have immunity for lying and cheating and stealing, right? They don't have immunity to do that. They are not licensed. They are not covered by the CPS integrity, okay? They're not cops. They're not even state employees, okay? They are nothing but state contractors. So they do not fall under the Immunity Act, okay? So that's the beauty of it. But unless you know this, parents just go, oh, she lied on the stand. That wasn't fair. Then you need to be suing her. You need to hit her with a lawsuit and show the caseworker she's not immune to lying. Okay? And that's going to be your best friend in all of this that you're doing, that the parents document. They have to prove that what she's saying is a lie. It cannot be hearsay. It has to be actual evidence. Okay? Actual evidence must prove that she is retaliating against you and committing a crime. Okay? That's the only way that you're going to win. Okay? So what if the entire county system is backing her up? Her lies? Have you proven her lies? So if you have actual evidence of the lies, it don't matter if the county or the system is backing her up. You can sue her individually. Let them come and defend her in a lower court of civil suit, a civil tort, and see if they're going to stand behind her if you have evidence of lies. They're not going to support her. It doesn't matter if her husband is a police officer. If you have evidence beyond a shadow of a doubt that she is lying, it doesn't matter if the Pope comes and stands beside her. She has to prove beyond a shadow of a doubt that what she is stating is truth and facts. And if she cannot do that, and you have proof that she has lied, and I've had that happen. I had a mom who actually made laundry soap on that Etsy, Pinterest stuff. And in her CS-13, it said that she had a meth lab. And the caseworker swore up and down the white powdered stuff was meth, right? It wasn't meth. It was laundry soap. So I had the mom take and put a little bit of that so-called meth and have it tested. And it came back that it was laundry soap. Nothing more than laundry soap. Okay? So her evidence that she claimed she saw white powder, yeah, she makes laundry soap and makes these little bar soaps and stuff on Etsy's and stuff, and sells it. The white powder that she saw on her counter was not drugs. It was literally laundry soap. So that day, I had the mom, I had actually the officer is the one who helped us because the caseworker put in her report that mom had been cooking meth or cocaine. She didn't know which. It was white powder. And she was concerned because there was a strong odor in the apartment. Yeah, uh, odor of flowers and mixture of lavender and myrrh and sage and all kinds of smells. Absolutely, you're right. It had a lot of strong odor, but it wasn't cocaine. It wasn't meth. It was laundry soap. Okay, they took her kids because of laundry soap. Okay, and we proved it. Mom's never had a drug in her life. She proved with hair testing and all kinds of stuff. She's never done drugs. Ever. Ever. Okay? So for them, and we, of course, brought in all of the soaps and stuff and the receipts of all the soaps and stuff that she sewed online. I'm telling you, these people are desperate. They claimed stuff that they shouldn't. Okay? It's a small county. I haven't seen my daughter in 9 months, backed by the court. There are 3 judges in the court. I'm dealing with, there is no proof needed, Max. Wait a minute. She has stood behind my ex for 2 years lying. He's abusing my daughter and keeping her from me. The CPS worker has me founded for abuse and neglect and mental injury. This is after he has had her a year. Her behaviors are so bad she's mentally injured because her father is abusing her in every way. It's been a 2-year fight like hell. They never had any evidence. All right, Sarah, I am more than happy to brainstorm with you on this, but not on here because this is pretty personal, and I will definitely, here, I'm going to send you a message real quick. Make sure to contact me tomorrow. I'm going to give you my phone number and we can discuss this. All right. I'm also going to put in the chat here, guys. Okay. I'm going to put in the chat my phone number. You guys have access to my phone number. Please be respectful of my time. Don't call me at 2 in the morning unless you've got CPS at your door or the cops or something like that. I do sleep. I get very little sleep. I have an autistic son. So just respect my time. Try to call me during business hours. Now, Monday's my day of counseling, so a lot of times I'm not free. I am free from like 9 to 2 on Mondays. The rest of the evening is for counseling. I have counselees that I work with. Tuesdays, again, it's from 9 to about 5. And then the rest of the week, you can call me from 9 to 8. So any of those times is fine. But I do trainings on Thursdays and Sundays, 1 to 6 and 2 to 6 on Sundays. So those time frames are also pretty busy. So just to kind of give you an idea of what I'm doing. Okay? All right. So if there's not any more questions, just feel free to reach out to me. I'm hoping that you guys was able to learn something today. Feel like you've learned something today. If you have any questions, like I said, feel free to reach out to me if I wasn't able to cover something on here. If there's something you guys need me to cover, I'm more than happy to cover that. We have a little bit more time here. But if we don't have any more questions or anything, feel free. Like I said, if you think of something later, you go, oh man, I wonder about this, feel free to reach out to me, okay? More than happy to answer any questions. I appreciate you guys coming to this class today. I appreciate you willing to learn and willing to try to make a difference. Those that are here as advocates trying to learn, and those that are here that are trying to learn to better themselves on their cases. I'm more than happy to help you brainstorm if you are stuck and don't know what to do. feel free to reach out to me. Each and every one of you, the 4 people here, have just feel free to reach out to me. Just remind me that you were on this class. Miss Nora, Julie calls me. She has access to me all the time. Janine, you feel free to reach out to me. Jody, feel free to reach out to me. Crystal, please feel free to reach out to me, okay? Miss Sarah, feel free to reach out to me, okay? And, yeah, and that, I have somebody, Miss Jody, that can help us with that. I've been studying. I told you I was going to study. There's an actual, okay, so there's an actual appeal that you as a family member can file. And I found that. It's with the Attorney General's office, okay? And I have somebody who is a paralegal that can help us write that up, because they failed to do their, what's called due diligence, okay? Remember where it says paternal, when it was talking about paternal family and stuff like that in the hearings? They have to find family. If they fail to do that within that 72 hours, they can get into a lot of trouble. And the fact is, your daughter gave them your name. Whether it was misspelled or not, the fact is your daughter had already given a relative that they did not seek out. Okay? So, feel free, guys. Like I said, I appreciate you coming to the class. I hope that you feel like you got something out of the class, that it was worth your time and your money. Like I said, I work really hard to help win on these cases, and I hope I haven't missed anything on presenting so that you can understand how important it is to understand the system. Okay? You have to use the system against the system to beat the system. So if you're having problems with judges and lawyers and police officers, there are things that you can file, which is abuse of power, abuse of conflict of interest, and you can file those things. You just need to know how. And like I said, I'm not a lawyer, but I do know how to point you in the right direction so that you can do it yourself. Okay? All right? And so there are things that you can do. All right? And like I said, I study every single day. I get a chance. And I God called me just for a time like this to help people. Do I always charge everybody? No. But I assure you that I will work harder than anybody, any lawyer, anybody that you have on your case. If I don't know the answers, I'll research it. When I was a parent aid company, parents would come to me and say, Miss Grace, I swear to you on the Bible, I'm not dirty. So you know what I did? I went and got my license and my credentials to take drug testing. 52-hour credits, college credits, to be able to own and operate my own drug testing company. And I would go with them and test their urine and their hair and prove to the courts they were lying on the parents. See a need, fulfill a need, and I did that. I took what I needed to do to help these parents that were being screwed by CPS. And they didn't like that too well. They said it was a conflict of interest. Conflict of interest? You're the one that's forging documents. You're the one that's not doing... I shut down 3 drug testing companies. 3 of them. Because they were illegally doing the drug tests. They weren't doing them right. And the only way I knew that is because I went and got drug tested certified myself. I paid $3,000 to get my company registered to be able to train other people how to do drug testing. And when I had a parent that had to do drug testing, I made them take my class, a 12-hour class for the urine testing, to learn how they were supposed to do the drug testing so that they could be a certified drug tester and say, you're doing that wrong. And when they say, well, you don't know what you're talking about, you can say, well, I'm certified to be a drug tester. You're supposed to do A, B, and C, and you're not doing that. I'm going to report you. Needless to say, when you educate parents, you empower them. Okay? And that's what I discovered. Education is power. Knowledge is power. And that's where you learn. Okay? And they take advantage of that. they think that, parents aren't going to fight back. Parents are just going to be, when you're told no, you can't have something, or no, you can't do something, they think you're just going to step back and go, oh, well, I can't do it. Oh, well, they said no. Don't take no for an answer. Absolutely don't take no for an answer. I had an aunt that ended up adopting her niece and nephew. She was told for 6 years, no, she couldn't adopt them. No, you can't adopt them. Guess what? I helped her, and she's adopted them. After being told over and over and over and over and over again, I said, quit asking. We're going to do this and this and this, and then you're going to file this. And next thing you know, they're like, what? They even appealed the decision from the judge. They were not happy. And she has now adopted them. She has them. And she's very happy. The children are very happy. And they had been in care for 6 years. Okay? In foster care. So it is possible. Okay? When they're telling you no, 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 there is a way. Okay? And I assure you that I think outside the box. I will research it if I don't know it. So I know there's ways. I don't do this sovereign citizen bull crap about, your birth certificate and all that stuff. I don't do any of that. Okay? That's not how you approach things, okay? Giving up your citizenship and all that stuff. That's not going to help you get your kids back. They're going to say you're psychotic. Don't listen to that stuff, guys. It's just going to hurt your cases, okay? So, any more questions before we go? I want everybody to have an opportunity. If I've missed anything, you guys understand how to work on this TPR, how to win a TPR, how important it is, documentation, how to get those documentations. Any questions, guys? Anybody? Everybody good? We ready to call it a night? I kind of thought you guys would have a lot more questions. I left an hour and a half for question and answers. I thought you guys would have more questions. I guess I hit all the oh, is this a hand raise, Jody? Maybe? I don't know. All right, guys. Well, again, I appreciate you coming. I appreciate you being a part of the class tonight. And like I said, my phone is open to you. If you need any help or anything like that, feel free to reach out to me. I don't know it all. No, I can't say that I do. But like I said, if I don't know the questions, I will help you research. Okay? All right. Perfect, guys. Absolutely contact me for an appointment. Feel free to reach out to me, and we will get that set up. Okay, Janine? All right, guys. Thank you. God bless you, and you have a great night. I don't know how to end the class. All right. Let's see, a new comment. All right, guys. Oh, here it is. This is how I end it.